You've not made it through anything I've asked you to make it through.
I know that you don't believe me with the tethers, but if I could take a lie detector test, I will. Since I got the tether,
Look, let's assume, for the sake of argument, that that's even remotely true. Let's recall the case People versus Angel Wilson.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Wilson, who stands to my right, please state your name for the record, ma'am.
Angel Wilson.
Thank you for passing this matter, Your Honor. Today is the date and time set for both sentencing and a bond violation hearing in this matter. As to the bond violation, Ms. Wilson will be pleading no contest.
Is that correct, ma'am?
Yes.
You understand that you'd be entitled to a hearing? Pardon?
Yes.
Okay. And so you're pleading no contest to that. Did you go to, so court will accept that admission or the no contest to the bond violation. Did you go to Von Swartz?
I didn't go there, but I talked to her and I sent her everything. I didn't.
Okay.
Go.
Well, why do I have this then? Man, she didn't go, but I thought they were going to re-refer her. Has she been assessed?
If I may, Your Honor, yes, she has. And she sent in the requisite paperwork on Thursday, but it was not received by Von Schwartz until over the weekend, but they did complete the report. And then that was the updated recommendation was sent out this morning for Ms. Polera.
Who did she send this to? Yes.
That was emailed to myself.
How old are you?
I'm 22.
What's your highest level of education?
High school and I'm starting college.
When? Pardon?
July 8th, my first day.
Where?
At PSI, it's a nursing school.
Are you living on your own now? Pardon?
Yes.
Where?
I live in Taylor.
So you moved?
Yes.
Why?
4 months ago.
Why?
Because I moved out of my mom's house.
I'm unclear, quite frankly, after reading all of this. I'm not. Are you living by yourself?
Well, my son lives with me. 2.5.
Pardon?
He's 2.5.
Did you pay Von Swartz already?
Yes.
I have concerns about this individual being, quite frankly, able to move through this report, whether she would be an adequate candidate for probation. But if you want to proceed with sentencing, we can.
Yes, Your Honor. I have reviewed the recommendation with Ms. Wilson. At this time, we are asking the court to largely adopt probation's recommendation. We do understand there is a 10-day or additional 10-day jail recommendation. Ms. Wilson is asking the court to not remand her at this time. As she has already told the court, she is starting nursing school on July 8th at PSI. Further, she does have a 2-year-old son whom she provides for. She currently is gainfully employed as a CNA, and she is anxious that 10 days in custody would both cause her to lose her employment or derail her potentially starting school on the 8th. Otherwise, we are asking the court to adopt probation's recommendation with the consideration of not imposing the additional 10-day jail time.
And what are you going to do if I do impose the 10 days? Ma'am, that was a question.
Me?
Yes?
I would just probably lose everything.
What are you doing with your life, young lady?
Right now, I work and I'm a mom and I'm a soon-to-be nurse.
Do you have proof of the nursing school attendance?
Yes, I did get approved.
Pardon?
I did get approved.
No, do you have proof of that?
I can show you an email on my schedule.
I think you need to come up with some reason why I shouldn't just send you to jail. Because I quite frankly don't think that you're a good candidate for probation. You weren't able to make it through the pre-sentence portion of this.
What does that mean?
Your bond violations.
Yes, I would like to say something about that. I've had to get 3.
You want to get 3 what?
I guess that would be irrelevant.
What?
I guess that would be irrelevant, so I won't say that, but
What would be irrelevant?
I just feel like it's something with the tether because I've had to get it replaced 3 times for an upgrade, and then it says that I violate. And I'm just really confused on that. And I know that the lady at Community Corrections has put stuff in my chart because I even offered to take a lie detector test to prove that I did not violate
Then why didn't you go through a hearing?
because I was told that I can't take a lie detector test.
Let's tell you the picture I have. I have a person who's violated. You had no contest today to those violations. Now you're telling me that. I have an individual who I'm not sure exactly what you're doing with your life, but who also, on the date of this incident, was extremely uncooperative while you were at the hospital. Your parents know about this?
Yes,
What do they say about it?
my mom, it's mainly my mom that has something to say. I mean,
What?
it's mainly my mom that had something to say. She
And what was that?
disappointed, but she knows that I made a mistake and I will never do that again. And
That's all that she said?
well, a lot more than that, but I don't really remember everything off the top of my head.
Why do I get the sense that if I put you on probation, that what's going to end up happening is I'm ultimately going to end up throwing you in jail?
Um, I don't think that that will happen. I've never been on probation, but I'm willing to do anything to go to jail because I have a kid, I work full time, and I'm about to start school. My focus is not to be in jail or to do anything to end up in jail.
Here's also part of the problem, because are you telling me that throughout all of your pre-plea, the pre-trial portion of this, that all of these violations were because something was wrong with the machine?
Well, I was on a whole, I don't remember what it's called in the beginning before.
Sober link.
Yeah, the sober link before I got the tether. If I'm being honest, I didn't take that serious, but when I violated and then got sentenced to jail, I knew I did not want to make that same mistake again, and I have not. That's why.
So what tells me now that you're going to take any sentence I impose seriously? I mean, that's my problem, young lady. My problem is I see you out there drifting. You go about pick up this charge. You're at the hospital. You've been drinking. You're at the hospital. You're absolutely uncooperative at the hospital.
I wasn't uncooperative. I just didn't want the IV. And yeah, I understand that.
They ask you for consent to draw blood, right?
Yes.
What happened from your perspective?
Well, when they said something about drawing the blood, I never refused it. I just wanted to sit up. And the officer stated that I couldn't sit up. So I was refusing. And then they ended up sitting me up to take the blood. So I,
And at that point, you didn't think this was serious?
I did. I mean, I knew it was serious from my accident.
So then you get arraigned and you get put on a sober line.
Yes.
Tells you what to do. You don't follow through on the sober line, right?
Correct. I was very irresponsible with the sober link.
Mm-hmm.
When I did the 5 days, I'm in jail. I knew I did not want to go back there and I did not want to violate. That's why I was saying I want to.
But why from the beginning didn't you take it seriously?
I feel like with my other lawyer, I didn't understand that it was a part of the bond. I've never had anything like this go on before. And I feel like there was a lot of miscommunication between me and my other lawyer.
You remember what you said to me about that tether and about the scram, that it was an inconvenience?
Unfortunately, yes, I do. And I apologize for that. That was really out of character.
So with all of that, what makes me think you're actually going to be able to make it through probation?
Um, I don't, the only thing I can do is show you if you just give me a chance.
I've given you opportunities throughout this case to show me, and what I've seen hasn't absolutely impressed me, or quite frankly, hasn't impressed me at all.
Yeah, I can understand that. I mean, I've never done probation. I'm willing to do probation. I'm willing to do anything, hopefully not jail time.
Why were you late this morning?
My son's dad had to come get me, bring me here.
Said, be quite frank with you, I don't know that you're a good candidate for probation. I don't entirely understand why I shouldn't just give 93 out of the gate, just be done. You've not made it through anything I've asked you to make it through.
I know that you don't believe me with the tethers, but if I could take a lie detector test, I will. Since I got the tether, I have not.
Look, let's assume, for the sake of argument, that that's even remotely true. You've been on two different types of tethers.
I was unaware of that. Is the sober link a part of a tether?
That's a kind of a tether.
Okay.
And you mess that up. So then, put you on the other side. What ends up happening? Mess all that up too.
But I didn't. That's why I want to take a lie detector test to prove that I did not. I mean, why would I want to go back to jail? Honestly.
When you went to Von Swartz, why didn't you fill the form out in its entirety?
Well, she told me there was only 12 pages and there was 23. And she said I must have printed it a different way.
Yeah, but there was information you left off.
Yeah, that I didn't.
But that was on what you had that you just didn't fill in.
Well, the question on the front, I didn't know. And the other ones, I must have just read through them. Not even, I honestly don't know. I was confused when she told me that there was stuff missing because it was like simple stuff, like my parents' name. I was like, what? So I don't know. I must have been rushing through it.
See, you need to come up here and give me every reason you have as to why I should send you for the 93 days.
Okay.
Court stands in recess.
All rise.
6:20. Court recalls case People versus Angel Wilson.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Wilson, who stands to my right, please state your name for the record, ma'am.
Angel Wilson.
So, explain to me, I asked you to think about why I shouldn't just give you the time.
Your Honor, Ms. Wilson does have a statement she would like to state to the court.
Well, I want to start off by saying that I apologize for my actions for the incident and what happened in general. Also, I apologize for the violations and making excuses for the bond violations. But I'm begging that you allow me to be on probation, and I understand that if I violate, then I'm going straight to jail. And I understand that probation's gonna be hard, but because I'm going to nursing school and I'm a mom, but I think I can do it. And I just would like a chance to show you that I can do probation.
How did you come up with the fee to pay Von Swartz?
I work,
Pardon?
I work.
How come you were late paying the fee?
I wasn't,
Pardon?
I wasn't, I sent it all together, the payment with the packet.
Yeah, but the packet was late.
I don't think so. I sent it Thursday, she got it Friday.
Your Honor, Ms. Wilson is employed as a CNA at an adult home, I believe. Is that correct?
Yeah. the
Yes,
nursing
so
home.
that might have been due to the income being not there at the time. And if Your Honor would like, I do have proof of a screenshot of an email of her enrollment or her class schedule rather, starting July 8th.
Were you,
program at PSI.
are you on the verge of being evicted?
One more time?
Pardon?
I didn't understand what you said.
How long have you lived at the Taylor address?
It's been 4 months.
Are you on the verge of being evicted from there?
As of right now, no,
Were you?
no.
Did you tell my probation officer that you were on the verge of being evicted and cannot come up with the fee?
No,
You never told her that.
no.
On the 19th of June, which would have been a Wednesday, did you tell my probation agent that? Did you talk to my probation agent?
Um, I honestly don't remember, but I know I never said anything about being evicted or I couldn't pay something.
So Miss Palera told that to me. She's not telling me the truth or somehow. Okay, that came from Carrie. Did you tell people at Von Swartz that?
No, like I sent her the money order with the packet. It was all together.
So you didn't tell them that you were on the verge of being evicted?
No, I never stated that.
When did you contact Von Swartz?
I called her, I want to say the Monday, and she told me to call her back Wednesday because she was on vacation.
Anything either of you want to say before I impose sentence here?
I just want to say that I apologize and I really hope that you give me the opportunity to do probation.
Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening assessment identifies the benefit of outpatient treatment, AA meeting attendance, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for probationary sentence supervision with stated rehabilitative goals to prevent recidivism, to monitor compliance of recommended treatment, and also to promote change. So therefore, the sentence of the court, you are placed on probation for a period of 18 months. You are to pay $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $540 probation oversight fees. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as requested by probation. You are to complete the CCOP program or a comparable program with proof to probation. You are to attend 2 AA meetings per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Have you attended that?
Um, Attended what?
The Victims Impact Panel.
I don't know what that is. No, I have not.
Have you signed up for it?
No, I have.
Young lady, let me tell you something. This is why I have this feeling you're not gonna make it through.
I was unaware that I had to sign up for the,
Your Honor, I'll make sure that she,
June 7th, I told you that.
I apologize, then I don't have an excuse,
Oh, I know.
but
There's not a lot of excuses at all for any of your behavior.
but I know for sure that I can do probation.
If you don't do these things, how are you sure you're gonna do probation?
I'm positive that I can, sir.
The scram tether will continue for an additional 60 days. In fairness on the jail time, Mr. Allen, I'm going to order 93 days in jail, credit for the 5 days you served. I'm not going to remand you for an additional 10 days. I am, however, because I think the intent here was the additional 10 days for the bond violations. However, you have already served 5 days for those bond violations. But I am going to remand the defendant to the Washington County Jail for 5 days, then the balance is suspended. Defendant is remanded. Court calls the case, People versus Jason Stevens.
Good afternoon, Your Honor. Olga Yermolenko, on behalf of Mrs. Stevens, who's present.
Your name, sir?
Jason Stevens.
On behalf of probation, Your Honor, the victim is in this case is present and would like to address the court.
All right, you two can step back and, hello,
Hello, Judge.
what's your name?
My name is Kashmir Morley.
All right, very good. What would you like to tell the court?
When I was 24, just barely out of college, I applied for a job as a note taker for an exhibit design company in Ann Arbor. I met Jason for the first time as an interviewer. We talked about career goals and how I was really interested in a graphic design role, though I was willing to take on other hats to get my foot in the door somewhere creative. Months later, he would hire me as just that, a graphic design contractor for his company. For 2 years, I did small projects for him, working my way up to be his design assistant. I was 26 at that time. For those 2 years, we forged what I thought was not only a strong creative partnership, but a friendship. I look back over that time now and see that those were 2 crucial years. He built my trust and my friendship as a form of predatory grooming. What did the title design assistant entail? Doing everything for this man, and I mean that quite literally. Jason would take me out to lunch one day on a long solo work trip back from Kentucky, where he and I would be sitting alone, to tell me that he and his wife were in an open relationship, something I would later come to find was a lie, to get in my pants. I remember feeling uncomfortable about him sharing this with me, his female understudy, who at the time was in an almost decade-long romantic relationship of my own. I chalked his transparency up to our close friendship and didn't put much thought into it again until he started bringing this up quite frequently. If you ever want to have some fun, let me know, he told me one day. I think you and I would be amazing together. I was, again, 26, and my long high school sweetheart relationship was falling apart, though no one knew, including Jason. Jason was 47 at this time and married with a child. Eventually, upon his probing, I would share with him that I was fresh out of leaving a long-term significant other. At this point, I was only 2 years out of college. My career was just starting to form. I was in a position of fragility in my life, and he knew that. I told him I didn't think it was a good idea. I told him that crossing that boundary would ruin our work relationship. He said to me words that would come back to haunt me. In September of 2023, you'll always have your job no matter what. The what became years and years of sexual abuse, emotional abuse, physical abuse, abuse of power. The what became me telling him no, and it happening anyway. I noticed that Jason began taking away work tasks from me whenever I wouldn't sleep with him. Every day I came into the office to do my job, instead became a game of mental gymnastics for me. Is he going to tell me I'm fired again today for no reason at all? Will he tell me I'm no longer working on this project for no reason that he can give me? The abuse was constant. If it wasn't emotional, it was physical. It took me 4 years of abuse to realize that there was an end to that sentence that he never spoke out loud. You'll always have your job no matter what, unless you tell anyone what I'm doing to you. I sat in my office the day he assaulted me, staring at my phone where I had typed 911. My finger hovered over that call button for what must have been 10 or 15 minutes. If I called, I knew my job was over. I knew I'd wake up the next day unemployed. I knew he would fire me for telling someone about his inability to keep his hands to himself. But the alternative was to keep letting him hurt me, and I couldn't take it anymore. I couldn't take one more day of the abuse. I would lose a month worth of wages after making that call. I would spend thousands in therapy trying to make sense of what he had done. I would worry about paying rent. I would worry about feeding myself, about keeping a roof over my head. And then I would began to worry that he would harm me further. In October, after the 911 call and Jason's arrest, he began to threaten me. He left a handwritten threat in my mailbox telling me to do the right thing in the middle of an impending trial. And I do say leaves because there was no forwarding address on that letter. Someone had to come drop it off at my house. And can you guess who was the only person at work who knew where I lived? When I didn't do exactly what Jason said, he started to show up at my house unannounced. He drove by my home and parked in front of my apartment dozens of times in an effort to make me feel unsafe, to make me feel like I had no other choice but to drop the charges against him if I wanted this to stop. Do you see a pattern? Jason has a back entrance from his house to his rental apartment, meaning he would not have to see me or be near my house at all if he wanted to check on his rental unit. Yet I continue to see him drive and park down my street. Any way imaginable that he could try to make me feel afraid is what I've had to live through and deal with since I called the police. When I didn't drop the charges, he started emailing me when there was a no contact order. And in every email, there was a threat. And every threat was sent from a fake name, from an email he and I set up for the sole purpose of setting up technology on the work site. I know this because I worked for him for 6 years. If Jason had actually wanted to message me something pertaining to work, he could have emailed me from his Jason @ handle as he had done for the past 6 years. But instead, he sends me back intellectual property that he stole from me from a fake name, minus anything I worked on for him, leaving me bereft for my own portfolio moving forward. And then tells me, I hope you got what you needed and we're in the clear, weeks before we're about to appear in court together. Jason J. Stevens, I am not afraid of you. Your threats do not work. It took me 6 months of intensive therapy to realize how badly he was abusing me. I entered the relationship with him consensually, but the abuse I endured was not consensual. The most disheartening part of this whole ordeal is being an up-and-coming young woman in a predominantly male profession and experiencing betrayal, mistrust, and abuse by someone I considered a mentor and with whom I looked up to. Jason could have made a difference in this world for not only young women like me, but young women like his daughter by holding his company to a higher standard than the one he created. And yet I am standing here today to hold him accountable for the actions he has done because he has chosen to do the opposite. I suggest battery intervention for Jason's probation. Jason chose to create a toxic workplace that is unsafe for any woman who steps foot on his job site. He created a world where women fail the moment they come to work. And if I have anything to say about that, that stops today.
Ma'am, I just want to clarify something. Thank you for that. Are you indicating that I think I'm aware of some of them, but that there was contact or alleged contact while this matter was
Yes,
at what points? Because
every month.
as I was listening to you, I don't think I have all of that, and I don't know that that's been taken into account with sentencing. Before you answer, Ms. Valera,
Yes, I don't have anything, Judge, so I don't.
Your
Oh.
Honor, we did raise the issue of the note on the document which was delivered by the defendant at the trial date, but the additional information, with the additional context, we did not.
no, okay.
I had
So
a,
that's what I'm a touch bit concerned about, that I don't have everything in front of me. I realize what you said in terms of where they were sent from, how you recognize them, whatever, but you still have those?
oh yeah, yeah, I had a whole FOIA document that I had forwarded, I think to Christine at one point.
Okay, so, all right. I think I want those.
Okay.
I want certainly Miss Polera to have those.
I can certainly give those to you.
The other thing that I'm wondering, and it kind of gets beyond the court's province, I think. You don't have this. You don't have this. As I understand that there was a work relationship, but there was also an intimate relationship at some point. Were we aware of that? Because here's my concern, particularly given what's been requested. As I'm reading the recommendation from probation, I would think that this would need to more look like, or should look like a DV sentencing as opposed to what it's charged as an assault and battery sentencing. I'm not saying go back and try to charge someone. I'm not saying any of that. I'm just saying in terms of the structure of the sentence, given at least what I'm hearing here, I think that that may need to be examined, particularly in terms of.
And Your Honor, I also know that Ms. Morley is asking for restitution. In the recommendation for probation, I was asking for a restitution hearing to be set, given light of her statement to the court, and probation being unaware of continued contacts and her indicating that she has proof of those. Probation would ask that the sentencing be adjourned, where I can reevaluate and look at everything to provide the court with a proper recommendation for sentence, as well as maybe address restitution all in one swoop.
Yeah, well, and that's what I was going to do that mainly because of the initial thing that was said regarding the contact, because I don't have that. And can't take that into account. I guess the other. Okay. And I realize at this point, it's in essence an allegation. The contact has occurred how often?
It's every month since he was arrested. So between October and March, I would say. That was in January. Yeah.
So there was contact in March?
Yes. For the very end of February to March. I can't remember the exact date, but it would have been like the last week of February, March.
Hey, ma'am, let me just ask you, when this contact would occur, what did you do with that?
I sent it to the cop who was dealing with all of this originally.
Pardon?
I sent it to the cop who was handling this case originally, or I called 911. So it's all documented.
Oh, well, I get that, but so
You
you,
didn't get any notice from the officer in charge of this case whatsoever about any violations that were sent to them by the victim?
He had a separate, what is the word? I'm blanking on the word for his arrest in March because of the stalking and harassment. Not complaint. He had a warrant out for his arrest in March because of all of the stalking and harassment.
okay, hold on. There's a warrant, you said there was a warrant out for him?
Mhm.
Out of where?
14A District Court.
Do you have anything?
Bench one issued March 4th, but I don't see why
March 4th on this case?
on this case.
I issued the warrant for failure to comply with bond conditions. Is that still active?
No, I show it's canceled. It was canceled March 27th. It looks like a different date.
When he came back, and that was part of the violations that he admitted to, that I'm taking into account in sentencing. So I get that one. But
That's all I see.
that's all you see in our system. So ma'am, you're of the understanding that there was a warrant of a new charge?
No, that's the same one that I'm thinking of.
Okay, that came out of this?
Yeah.
Got it.
Yep.
Okay. So, but so all of what you relayed to me today in terms of these contacts, those were sent to Pittsfield Township Department of Public Safety?
Yes.
Okay.
Or Ann Arbor as well, because I live in Ann Arbor, and so there was like a jurisdiction issue, and the cop said that he couldn't handle anything that was not in Pittsfield. So when he said, dropped the letter off at my house, that was Ann Arbor. So maybe that's the issue too.
So some of this is in Ann Arbor.
Yeah.
Some of it's in Pittsfield.
Yep.
Okay, beautiful. All right, and the prosecutor doesn't. Okay. So we'll have to round that all up. Ms. Yermolenko, is there anything you wanted to say regarding the request for an adjournment regarding the?
I don't have a problem. We were not, it's additional contact allegations. We were aware of with the two email contacts in, I want to say January. That's what the Warren Bar violation was for. We addressed it at the last.
Correct.
It was set aside. All those additional allegations I've never heard of previously, and I would like to see those police reports, so.
And I do also want to note for the record, I just ran through my email, I did not get anything directly from Ann Arbor or Pittsfield with regard to a bond violation. We did receive an email from Ms. Morley regarding the FOIA the information she received from the FOIA. I also just checked our internal file system, and the only case for Mr. Stevens, which shows all of the warrants that have been submitted as well, is this case. There is nothing.
It's nothing, okay.
So there has not been an additional warrant request from Ann Arbor or from Pittsfield with regard to this case.
Got it.
Or, I should say.
I spoke to the Pittsfield officer myself when we found out about the warrant. He did not mention any additional context, but once again, we're not aware of the additional context that would be mentioned.
Okay, but got it. Okay, and so that I'm also aware, and the claim for restitution is for general.
Yeah, she's asking for, to cover therapy.
Got it.
She did provide some, receipts. We were taking a look at those today. I don't think that I have everything. I think that she may be looking, for additional.
Got it. Okay, so May 8th probably not, it's gonna be too soon. Or, I mean, it's not too soon for me. I want everybody to be able to do the work. That's my concern. And Ms. Yermolenko has risen and she probably isn't available. Of course not.
But I have another problem with the 15th before.
Well, no, we don't do.
Is that gonna be enough time?
What about the 22nd? Your work? Okay, ma'am. So what I'm gonna do is I will adjourn this to May 22nd, 2024 at 9 a.m.
I'm so sorry, Rich. I thought it was gonna be in the afternoon.
Whoa. Now you're throwing things? Okay, yeah. You thought it was gonna be in the afternoon.
I did, I am scheduled to be in Dearborn Heights this report all morning, that morning.
No way.
I'm available in the afternoon.
Is that one in the morning?
It is.
It is. But I will
also be gone that day. Is it possible?
oh, heck, I'm gonna get out of town too. So we'd have to go to the next.
June 12th at 9 a.m.
June 12th work for everybody.
10 a.m. work. I have a thing in front of the car at 9.
He'll wait. No. Okay, no, go there. Let us know. Well, of course, you're just right up the street. Yeah, that famous last words. June 12th, 2024 at 9 a.m.